You're on live? Sir, you're on live. Good to go?
Recording in progress.
Okay, perfect. Good evening to all of you. Yesterday we were just discussing Order 22. Many questions were asked on that. Order 22, the title of Order 22 is Death, Marriage and Insolvency. Here, unlike a criminal case, a civil suit does not die with the death of a person, be it the plaintiff or be it the defendant. There is a procedure that is prescribed to say that once death occurs, the persons who come into the estate which comes into the hands of the widow or sons or daughters or whomsoever it may be, the action survives, be it the plaintiff or be it the defendant. Here, first and foremost is that here Order 22 speaks about bringing the errors on record. To recap what we have done yesterday, as far as the plaintiff is concerned, when the plaintiff dies, the illars are the sons, widow, and the children of the deceased. A petition can be filed under the provision of Order 22, Rule 3. When the plaintiff dies, his legal representative can be brought on record. Then the question arises, sir, who is a legal representative? A legal representative is a person where the estate of the deceased comes into his hands. He is called the legal representative. It can be the son, it can be the widow, it can be the daughters also. And the procedure that has to be followed when the plaintiff dies is to file a memo into the court and request the court, sir, I wanted to take steps because one of the plaintiffs died. I wanted to bring the errors of the plaintiff on record, and the petition has to be filed under the provisions of Order 22, Rule 3, petition accompanied by an affidavit saying that so-and-so died on so-and-so date, and the right to sue survives. As far as the legal representatives are concerned, I wanted to bring these people on record. Then notice is issued to the opposite side, and the opposite side is directed to file his counter opposing the application. Then the petition is heard, and then the court orders that so and so to so and so can be brought on record as the co-plaintiffs, as the legal representatives of the deceased plaintiff. This is Order 22, Rule 3. And Order 22, Rule 4 speaks about when one of the defendant dies or the defendant himself dies, then in that case, it is the duty of the plaintiff to file a petition under Order 22, Rule 4. That is what is called an IA or interlocutory application, accompanied by an affidavit saying that the errors of the deceased defendant are so and so, so and so. Then, on an application being filed into the court hears the matter and then decides as to who are the errors, and they will be brought on record as co-defendants. Please remember one thing, that once you file an error application, you are also supposed to file the consequential amendments under Rule 28, Civil Rules of Practice, stating that how the cause of action survives as far as the legal representatives are concerned. Then this application, be it under Order 22, Rule 3 or Order 22, Rule 4, has to be filed within a period of 90 days from the date of death of the deceased. And once the application is allowed, the amendment has to take place as far as the plaintiff is concerned. Yesterday also I told you, it is only the plaintiff who has initiated the suit can implead the errors in the record. It is not the defendant. Though one of the defendant dies, it is only the plaintiff who has to make the necessary corrections and alterations in the plaint. And once the alterations are made, or let us say the amendment is carried out, then you are supposed to file what is called a fair amended plaint. And once a fair amended plaint is filed into the court, there is an opportunity to the in case the last please unmute please. In case the legal representatives are brought on record, then the additional parties who have come on record have got an opportunity of filing additional written statement, if any. Then the trial goes on. This is what Order 22 Rule 4 speaks. Order 22 Rule 3 and Rule 4 speaks about. But the period within which this application has to be filed is 90 days from the date of death, be it the plaintiff or be it the defendant. But sometimes it so happens that other plaintiffs are already there on record or other defendants are already on record. Then you can file a memo into the court, sir, no need of bringing LRs on record since the LRs are already on record. The period of filing this application under 20 or 22 Rule 3 or Rule 4 is 90 days. Suppose that 90 days expires, then what happens is the suit suffers a legal death as far as the deceased plaintiff or deceased defendant is concerned. Then, in that case, you are supposed to file an application under Order 22, Rule 9, asking the court to set aside the abatement that has taken place or where the legal death has taken place because of the LR application being filed, not being filed. Then, in that case, the court can set aside the abatement on such a petition under Order 22, Rule 9. Again, what you file into the court is an IA or what is called an interlocutory application accompanied by an affidavit supporting the petition. Then, once the abatement is set aside, then comes the LR application, and the LR application will be allowed once the abatement is set aside. Then, the period for within which an application to set aside the abatement has to be filed is 60 days. 90 is for bringing the LRs on record, 60 is for setting aside abatement. Then let us say even 150 days has expired, you have not filed the petitions. Then in that case, you will have to file an application under Section 5 of the Limitation Act for condonation of delay in setting aside the abatement or bringing the LRs on record and explain each days of delay. And then in appropriate cases, the court orders for delay being condoned. And then once the delay is condoned, then comes the abatement petition. Then next the abatement petition is heard and disposed of. Then once the abatement petition is heard, then comes the LR application. And the LR application will be heard and disposed of according to law. And here there are three steps when you file a delay petition. But in most of the delay petitions which are filed under Section 5, courts are not adamant. Courts are not that strict. They normally allow the delay petition on payment of costs to the opposite side, and the delay will be condoned accordingly. Then comes to when there is a dispute regarding whether a person is an LR or not, then in that case a regular inquiry is held under under Order 22. That is under Order 22, Rule 5. Then once the determination is made, then the court permits your application. Then suppose you come across a situation that under 4A, when there are no LRs of a party, then the nearest relatives who are there, who intermeddle in the estate, can always be brought on record as the intermeddler. That is Order 22, Rule 4A. Then suppose a hearing already takes place and abatement has taken place. Then in that case, Order 22 Rule 6 says there cannot be an abatement once the hearing is completed, evidences are completed. That is Order 22 Rule 6. Then comes Order 22 Rule 7. Suppose a female, when the suit is instituted, she was a spinster, then she was unmarried. Later on, she gets married to some other individual. Then, in that case, there is no question of any abatement. She will only the description will be there. Instead of saying daughter of, she'll be described as wife of. That is, as far as marriage is concerned, there is no abatement. That is Order 22, Rule 7. Then the question arises, sir, what is the effect of abatement? The effect of abatement is you don't bring the LRs on record within the time stipulated, or you don't file a petition to set aside the abatement. Then, as far as that individual is concerned, the suit suffers a natural death. And here it is said that you cannot file a fresh suit in respect of the same cause of action in the court of law. That is Order 22, Rule 8, please. Then we go to Order 22, Order 22, Rule 8. Here, here we come across insolvency. I think most of you know what is the meaning of insolvency. To put it in the English language or in English law, it is called bankruptcy. Insolvency means where a person files an application for being declared as an insolvent. And then let us say during the pendency of the suit, he dies or he expires. Then in that particular case, what happens is the receiver of the court, an officer of the court is appointed as a receiver, takes over and fights the litigation. And insolvency has no effect as far as the suit is concerned. Then next one is procedure in case of assignment before final decree. Sometimes what happens is I think most of you being advocates know that there are so many people hovering around courts. What they do is they try to purchase litigation properties and assure the plaintiff that they will fight the litigation, they will finance the litigation, and then the question is they take an assignment. Assignment means they take over the rights of the plaintiff or the rights of the defendant. They are called the assignee. Then they can file an application before the court. Sir, we are the assignee of the plaintiff or the defendant. Please recognize our rights and we will fight out the litigation. That is what Order 22, 22 rule, states. Then uh, Order 22, Rule 10 says it is the duty of every advocate, be it the plaintiff or be it the defendant, to communicate to the court, sir, my party has died, sir, expired, either the plaintiff or the defendant. Then the court records saying that the plaintiff or the defendant has expired, for it posts it for steps. That means it's not a charity. It is your duty to report to the court by filing a memo saying that the party dies. Then it is for the other side to take whatever steps he has to take under the law. Then next one is the then question arises, sir, if an appeal is filed against the decree passed by the lower court, when an appeal is filed, what is the remedy? The same provisions which apply, that is Order 22, Rule 3, or Rule 4, or Rule 9, applies as far as appeals are also concerned. Why? Because an appeal is supposed to be a continuation of the suit. A suit does not die with the lower court, it continues till the appeal is disposed of. Appeal is a statutory right which is given to a party, and whatever applies as far as the suit is concerned also applies to appeals. Then what happens is uh, application of order to appeals, and next Rule 12 is application to proceedings. Suppose an interlocutory application is there either in the lower court or in appeal, the same procedure that has to be followed under Order 22, Rule 3 and Rule 4 has to be followed, and there is no separate provision for bringing the LRs on record as far as appeals are concerned or proceedings are concerned. Why I'm saying proceedings is interlocutory applications. The necessary amendments can be made even in the applications or interlocutory petitions that are pending before the court. That is order 11 and order 12. I mean, order. I think that is Rule 11 and Rule 12. Then we go to. Am I making myself clear to you, please? Then we go to the next order, that is Order 23. Order 23 deals with withdrawal and adjustment of suits.
Good evening, everybody. I request the audience to mute their audios so that the lecture goes smoothly. Please, that's a small request for everybody. Thank you. So continue.
Then we go to the other provision called Order 23, which deals with what is called withdrawal and adjustment of suits. In Urdu, there is a saying, Mia Bibi Razi hai to kya karega kazi. Suppose the plaintiff and the defendant agree to settle their matter and withdraw the suit as fully settled. No, the court cannot stop them from settling the matter. Here, sometimes what happens is, suppose you file a suit for, let us say, 50 lakhs, and there you say, sir, I'm confining my claim only to the extent of 30 lakhs. The other 20 lakhs, I may not be able to prove it. Then in that case, the court says it is an abandonment of the part of the claim. That is, the abandonment is giving up or relinquishing or releasing part of the claim. That is what is called abandonment of suit. Or let us say you don't appear at all, you don't make a representation, or you don't prosecute the matter, then it is deemed that the claim is abandoned or left, or not to be argued. Then, in that case, one more thing you must remember here is withdrawal of suit. Most of us, what we do is we file a suit, and let us say we have got a fresh cause of action also. Then, in that case, sir, this particular claim which I have made has outlived its purpose. I have got a fresh cause of action, and it is within limitation. Please permit me to withdraw the suit, and with permission to file a fresh suit in respect of a comprehensive claim. That is Order 23, Rule 1. That is giving up part again, that is requesting the court to permit you to withdraw the suit and also permit you to bring a fresh suit on a fresh cause of action and on subsequent reliefs. That is Order 23, Rule 1. Please bear one thing in mind, that once you let us say, but a claim is not maintainable because of various reasons, then you want to file a fresh comprehensive suit. Please remember, you cannot file a fresh suit unless and until you take the permission of the court by filing a memo or filing a petition saying, sir, I wanted to withdraw the suit. Please permit me to withdraw the suit with permission to file a fresh suit in respect of the cause of action or the subsequent cause of action which has accrued to me. That is, permission of the court is absolutely mandatory as far as Order 23, Rule 1 is concerned when you want to withdraw the suit. Then, next one is Order 22, Order 23, Rule 1A speaks about what is called when transposition of defendants to plaintiffs may be permitted. A suit is filed, let us say, sir. The plaintiff is colluding with some of the defendants, and one of the defendant feels that his interests are being jeopardized, and the plaintiff is not taking interest in the suit. Then, in that case, he can make an application under Order 23, Rule 1A, saying that he has got a community of interest and he has got a common cause against the parties concerned, and that the plaintiff is not taking interest. Please transpose me or transfer me to the array of plaintiffs instead of the defendants. Then, under Order 23, Rule 1A, when the court finds that you have got a community of interest and that the plaintiff is colluding with the other defendants, and the interest of this defendant who wants to be transposed is being jeopardized, then under Order 23, Rule 1A, instead of you being a defendant, you can be transposed or transferred to the array of plaintiffs. That is what is called Order transposition of parties. That is Order 23, Rule 1A. Then we go to the next provision, limitation law not affected by first suit. Suppose you withdraw the suit and with a permission or with liberty to file a fresh suit, the question of limitation does not arise as far as your second suit is concerned, because the court has permitted you to withdraw the suit and given you permission to file a fresh suit. That is Order 23, Rule 2. Then we go to the most complicated part of it, is called compromise. That is Order 23, Rule 3. That is Order 23, Rule 3 speaks about compromise. What do you mean by compromise? Please remember, nowadays, because of the court, the litigation delays, courts are encouraging compromises. When both the parties agree to settle their matter, it can be put into writing by way of mutual, that is a memo of compromise signed by both the parties, signed by both the advocates, and with permission to enter into a compromise, that is under Order 23, Rule 3. Then the court, when the compromise petition is filed, the court goes into it, then settles the matter and records the compromise in terms of the joint memo that is filed by both the parties. This is what is called compromise. Compromise means settling the matter amicably between the parties. Please remember, it's a very distant dream. Even if one party agrees, the other party doesn't agree. But still, because of the court delays, parties come to a settlement. Settlement should be encouraged at all times, and that is the reason a compromise is always recorded and encouraged by courts. And please remember, once a compromise petition is filed, and then a joint memo of compromise is filed, it is the duty of the court to read out the compromise and take an admission from the party whether they are agreeing to the terms and conditions stated in the joint memo. And then only when it is read out and explained to the party, the compromise can be recorded under Order 23, Rule 3.
నువ్వంటది కాదంటే గొడవ వస్తారు ఇంకా అన్నట్టు నువ్వంటది
Can a compromise be questioned? Suppose, let us say, a joint memo is filed, the court records the compromise, the decree cannot be questioned in any court unless fraud is alleged. That is what is called Order 23, Rule 3A. Then we go to Order 23, Rule 3B, which speaks about, I think I have discussed this also, representative suits which are filed under Order 1, Rule 8. That is when two or more persons represent a body of persons who cannot come to court, then the court grants them permission to institute the suit for and on behalf of the body of persons who have got a community of interest. And in that case, what happens is, suppose a compromise is arrived at by these representatives on behalf of the other plaintiffs or defendants, as the case may be, then in that case, all the parties will have to be present on the day when the compromise is recorded. Their objections also will have to be heard, and a compromise can be recorded only in those circumstances. So, in a representative suit, when two or more persons represent the other body of persons, then it is absolutely mandatory that when a compromise to be recorded, all the parties who have got community of interest will have to come to court and agree to the terms and conditions stated in the compromise memo. Then, then proceedings in execution of decree not affected. Then Order 23, Rule 4 says that as far as abandonment is concerned, if any proceedings are taken in execution of the decrees, they are not affected and the compromise will take precedence. This is what Order 23 speaks about. That is what is called withdrawal and adjustment of suits. And please remember, once the suit is compromised, the terms of the compromise is reduced to writing by signed by both the parties and both the counsel, and then it is read over and explained to the parties. It results in a compromise decree being passed. And once a compromise decree is passed, the question is the suppose, let us say, it is not obeyed or complied with. Then in that case, when execution proceedings have taken place, then the question is that is it, the execution is not affected in any way. That is Rule 4. Then we go to Order 24. It's a very small order, please. Here, payment into court, sir. Most of you know money transactions. Here, that is, once the defendant deposits the entire money or part of the entire money, rather, covered by the decree into the court, with notice to the other side, then in that case, the interest ceases to run from the date of deposit. Or during the pendency of the suit itself, it deposits the entire money. The question of no interest can be computed later. That is why it is said payment is one advantage where it prevents interest being accumulated. Then here the question is, once it is deposited and notice is given to the other side, the other side, that is the plaintiff, does not get any interest in respect of the amount that has been deposited. Then once the actually let us say it is paid in part, Once it is paid in part, it is incumbent upon the plaintiff to file a memo into the court, say what is called PS memo. PS means part satisfaction memo. That means to the extent of the amount that has been paid during the pendency of a suit, the part satisfaction will be recorded and the decree can be passed only for the rest of the money. If the entire amount is paid, then the question of FS is recorded. FS means full satisfaction is recorded that the matter has been decided, settled between the parties. Then once the FS is recorded, it puts an end to the claim. This is what Order 24 speaks about. Then we go to Order 25, that is security for costs. Here, sometimes it's not always necessary that the plaintiff should succeed. Sometimes the defendant has got a stronger case than that of the plaintiff. Then the court orders what is called security for the cost to be a cost which is incurred by the defendant to be furnished by the plaintiff, that are Order 25, Rule 1, within a particular time. Are you able to follow, please? Suppose the defendant has got better chances to succeed than the plaintiff, the court can, in special cases, order for security to be furnished by the plaintiff as far as the defendant's costs are concerned. That is Order 25, Rule 1. Then Order 25, Rule 2 speaks about what is called, suppose, let us say, the court orders for security and the plaintiff absconds from the jurisdiction of the court. Then, in that case, whatever property is owned and possessed by him will be attached for the satisfaction of the claim of the defendant, which is going to be made at a later date. Then we go to the next provision, Order 26. Order 26 speaks about commissions. What do you mean by commissions? Commissions doesn't mean a percentage that has to be given. No. Commission in the legal sense mean, suppose, let us say, a party is not in a position to come to court either because of physical and mental disability, or is hospitalized, or is confined to bed, an application, or is an aged person. Then in that case, an application can be made to the court, sir, please appoint an advocate commissioner to record the evidence of the witness at his residence or at his office. Then a commissioner advocate, the court delegates its functions and then appoints an advocate in appropriate cases to record the evidence of the party whose evidence is required. That is what is called commission issued for examination of a witness. Then once a commission is issued, the advocate who is appointed is given a warrant whereby he is given the authority to go and examine or cross-examine or record the cross-examination of a witness and then report to the court and file his report into the court. That is what is called examination of a witness on commission when he is unable to come to court because of his sickness, because of his ailment, because of his physical and mental disability. Then in that case, and mostly people who are very, very busy, especially doctors and surgeons, in most of the accident cases, court appoints a commissioner to record the evidence. Why? Because the presence of the doctor cannot be procured without enormous delay. Then in that case, an advocate commissioner goes to the hospital, takes an appointment with the doctor and records his evidence or cross-examination and then reports to the court and files a report into the court called the commissioner's report. Then once a commissioner's report is filed into the court gives an opportunity to both the parties to file their objections. If any statement is misquoted, any statement is wrongly recorded, then in that case, the statement that is wrongly recorded can be reported to the court, and the court again demits the matter to the commissioner to record it in a proper way. Then we go to the second type of commission, which is called commission for ascertainment of mean profits. Here I told you that in a suit for eviction and possession in Transfer of Property Act, what happens is mean profits are also asked. What do you mean by mean profits? Mean profits means the damages and compensation which is liable to be paid by the tenant to the landlord in case he squats to the property even though his tenancy has been terminated. Then After the expiry of the notice, the landlord or the plaintiff becomes entitled to claim damages. It is in the form of mean profits. Here, mean profits are normally not fixed by the court because adequate evidence is not available. Then, in that particular case, a commissioner advocate is appointed in a petition filed under audit. Petition filed, a commissioner advocate is appointed to record the evidences of both the sides and then find out, verify what is the probable rent the property can fetch in case it's let out, considering the location, considering the status, considering the position, considering the neighbors and the evidences and the documents which are placed on record. Then, once the commissioner files the report, the court looks into the report and then passes a decree saying that the plaintiff is entitled for mean profits at the rate of so and so from the date of expiry of the notice till date of payment. And please remember, for all practical purposes, this particular inquiry which takes place, a decree is passed saying that the plaintiff is entitled for. So, in these cases, in cases of inquiry regarding mean profits, a commissioner can be appointed in a suit for eviction under the Transfer of Property Act. Then we come to the third type of suit where commissions are issued is in a partition suit where a definite share is claimed by the plaintiff against the defendant and the suit upholds that you as the plaintiff is entitled for a particular share. Then a commissioner advocate is appointed who is asked to go to the spot, measure the land with the help of the revenue officials, and then demarcate the land, localize the land, fix the boundaries, and then report to the court that this is what I have done. Files a commissioner's report. And once the commissioner's report is filed into the court are based on the commissioner's report. After objections are heard and decided, then the court passes a decree saying that the plaintiff is entitled so much amount towards mean profits. Then please remember, when you have not paid the court fee in respect of the amount what you have claimed as damages or mean profits for use and occupation, you have to pay the excess court fee which has to be paid. And then once the excess court fee is paid, the decree is drafted and you can execute it as if it is a money decree. This is the third instance where commissions are issued for ascertainment of mean profits. Then the fourth one is partition. As far as partition is concerned, suppose the court holds that you are entitled for a particular share, then an advocate commissioner is appointed who goes to the spot, measures the land with the help of the revenue officials, and then localizes the land, fixes the boundary stones, and then reports to the court and files his report into the court. It is called a commissioner's report, and based on the commissioner's report, either by allotment or by lottery, shares are fixed and allotted to the respective parties. This is the fourth instance where a commissioner is appointed. Fifth one is when a suit is filed by a partner claiming a share of profits in the business where he was a partner before relinquishing his rights as a partner. Then, in that particular case, a commissioner advocate is appointed to go to the business premises, inspect the accounts, and then note down what is the profit which is accrued to the firm and how looking into the balance sheet and looking into the various reports, then it says these are the profits and the plaintiff is entitled for so much amount towards his share of profits. Here also I told you yesterday itself that two decrees are passed, one called a preliminary decree and another called a final decree. Then the next instance where a commissioner is appointed is in the case of mortgage suits. In the case of mortgage suits, what happens is a commissioner advocate is sometimes appointed to go to the spot, inspect the property, fix the stones, and sell the property by public auction. A commissioner is appointed for that particular purpose. So then next one is a commissioner can be appointed even for the purpose of local inspection. Then what do you mean by local inspection? Local inspection means to make a physical verification of the physical features on the property. What is on the east, what is on the west, what is on the north, what is on the south, what are the impugned constructions that are made by the defendant, and then to what extent it has been made. All these things can be noted down. After work memos are filed by both the parties, then the commissioner files a report into the court as far as local inspection is concerned. Then next one, where a commissioner can be appointed is a commissioner can be appointed for the purpose of making an inventory. What do you mean by inventory? Inventory means make a note of all the stocks that are available, make a note of all the furniture that is available, make a note of all things that are found at the spot, and then report to the court and file a commissioner's report. These are all the various instances where a commissioner can be appointed instead of the court wasting its time. The matter can be delegated to a commissioner to do the job as far as the court is concerned. Of course, it's subject to objections being filed, the respective parties being given a liberty of hearing as far as the objections are concerned. And then once the objections are overruled, then the court passes a decree based on the commissioner's report. These are the various instances where commissions can be issued by the court, where a delegation can be done, where the commissioner can be asked to do what the court can do, and then based on the report given by them, the court passes a decree. Then sometimes what happens is experts are to be examined. Experts do not have time to come to the court. Then, in that case, a commission can also be issued to examine them at the place where they reside, and then they record their cross-examination, and then report to the court, and the court passes an order looking into that evidence. Then this is as far as Order 26 is concerned. Then we go to what is called suits against government or public officers. That is Order 27. What does Order 27 says? Here we have got ours is a federal structure. We have got the union government at the fulcrum, that is the highest court, and below the union government, you have got what is called, they call them as Union of India, and below them you have got the state governments. They are called the state governments in the respective states, and the central government also has got various agencies, the public sector units, or let us say government undertakings. Even the state government has got similar institutions. Then, when you want to file a suit against the government or the public officer, what is the procedure you have to adopt? The procedure which you have to adopt in such cases is that when you file a suit against the government, be it the state government or Union of India, then in that particular case, when you file it against the central government, you will have to describe it as Union of India owning the South Central Railway or whatever it is, represented by general manager. You cannot sue a person who is a public officer in the individual capacity. You have to sue them only in a representative capacity. That's why we say Union of India owning Bharat Heavy Electrical, represented by its CEO or whomsoever it may be. Same thing applies as far as when a suit is instituted by the government against an individual. They have to describe themselves of Union of India owning the Bharat Heavy Electricals Limited, a public undertaking represented by its CEO or whomsoever it may be. Then, when a suit is filed by the state government or against the state government, you will have to say State of Telangana, that is State of Telangana, owning the so many corporations and all, represented by its general manager, so and so. So, no, when you file a suit against the government or when you file a suit against a public office, you can only sue them in the representative capacity, but you cannot sue them in their individual capacity. That is what Order 27 speaks about. Then Order 28, of course, these are all small things. When I come to sections, I'll deal with in detail. Order 28 speaks about suits against military, naval, or airmen. That is, they are concisely called the armed forces. That is, as far as armed forces are concerned, their continuous presence is always required. That is the reason why we say that when you file it against the army, let us say army officer, you will have to get him represented by his commandant. He is the proper person, and you have to take the permission of the court to sue the army officer through his authorized officer or the superior officer. Same thing applies as far as naval and airmen are also concerned. Then we go to Order 29. Order 29 speaks about what is called suits against corporations. What do you mean by suits against corporations? If you have got the knowledge of the Companies Act, a company by incorporation gets a separate status. It has got a perpetual succession and a common seal. And a company is a body corporate. And the first case of the Companies Act, Salomon's case, Salomon was a Salomon Company Limited. That is, even a one-man company can be a company. A person cannot say, I am the company and the company is myself. No. A company has got a distinct existence and it's a corporate body. And like any one of us who are individuals, the company also has got an independent existence. So when suits are brought by the company or suits against the company, then in that case, it should be brought in the name of the corporate name. Then the Bharat, that is this Bharat Heavy Electricals or whatever it is, you will have to sue it in the company's name. You cannot file it in the individual name. That is, as far as company law is concerned, directors are normally not personally liable. But under the new act, the Companies Act of 2013, the directors are also personally liable in certain instances. So when a suit is filed or brought by a company or against a company, the company has to be described in the representative capacity and not in the individual capacity. A person who owns the company is no way liable, but a company alone becomes liable because company is a distinct entity. That is what Order 29 speaks about. Am I making myself clear to you, please? Next one I'll describe also. Here, Order 29 says a company, since it has got a distinct existence, it's a corporate body, it's a body corporate, it's a fiction of law that a body is created and it has got an independent existence. So, individual directors cannot be made liable, cannot be made responsible, and all actions for and against the company has to be brought in the corporate name and not in the individual name. And you've got chit fund companies also. You say Margadasi Chit Fund Private Limited, represented by its managing director. But you don't make the managing director a defendant or a plaintiff. Why? Because the managing director is only runs the agency or runs the company. He runs the company in his representative capacity, but not individually. Then, in that case, all suits for and against the company has to be brought in the corporate name and not in the name of an individual. So a company has a distinct existence, and please remember it is said in the company law, even if the last shareholder is dead, the company survives till it is wound up by the proceedings of liquidation in the NCLT. Then we go to the next order, that is Order 30. Order 30 speaks about suits for and against the firms. Please remember, if you have read the Partnership Act correctly, a firm has no independent existence. A partnership has been defined as an agglomerate or combinations of two or more persons who join together, build up a foundation called the firm, on which that is two or more persons come together, pool up their resources proportionately, and build up an edifice called the firm, on which the firm rests, and ultimate object is to run the firm and churn out profits and distribute it among its partners. It is called a firm. But if you see the Partnership Act, it only defines a firm as an agglomerate of two or more persons to share the profits of a business. Please remember, where is the question of getting profits when you don't have vitamin M? The proportionate contributions will have to be made by two or more persons and build up a capital. That is called the foundation, on which the business rests. That is called the superstructure. And ultimately, to run the business and churn out profits and to distribute the profits among the partners as far as the business is concerned, that is what is called a firm. Collectively, it is called a firm, and individually, the persons who are part of it are called partners. And the incidence of partnership also, that a death of a partner or insolvency of a partner ipso facto puts an end to the firm. And once the substratum goes below 2, the firm automatically dies, firm automatically gets dissolved. Then in that particular, that is why it is said a firm should consist of more than 2 or more persons. Then, as far as when a suit is filed by a partnership firm, it should be brought in the name of the firm represented by all the partners. That is 1, 2, 3, 4, and 5. But normally, when you file a suit under Order 30, what we do is we file it on behalf of the firm represented by its managing partner, so on and so forth. But Order 30 says all the partners will have to be made as parties, as co-plaintiffs or co-defendants when the suit is filed by the firm against a third party. And if the third party is the defendant is also a firm, then get it represented by its partner. But please remember, a firm has no independent existence sans its partners. That is, if the partner dies, automatically the firm cannot bring a suit or the firm cannot be sued. As far as the firm is concerned, it is an agglomerate or combination of 2 or more persons. So whenever a suit is filed by a firm or against a firm, it has to be brought. It has to be brought getting it represented by its partners. Then again, also here I say there is a legal embargo which says, and the Partnership Act, the firm should be registered. That is Section 57 of the Partnership Act says no suit can be filed by a partnership firm unless it is registered. That is Section 57 of the Partnership Act. Then we have got one more enabling provision in the Partnership Act called Section 69, which says when a suit is filed by a partnership firm, it has to be registered, number one, and the person suing or the person who is bringing the suit for and on behalf of the firm should be mentioned as a partner in the extract of partnership that is normally called the Specimen A form under the Partnership Act or Form A. So two things have to be satisfied. One is firm has to be registered and the person who is bringing the suit should be mentioned as a partner in the extract of partnership. And both the documents will have to be filed along with the suit. If the firm is registered but the person who is bringing the suit is not authorized to bring the suit, then the suit fails. This is what Order 30 says. Then what is the distinction between company and firm, sir? Company has got an independent existence. Company has got a corporate existence. It is an independent person. It does not depend upon the life or lives of the shareholders for its existence unless it is wound up by an order of the court. But as far as the firm is concerned, unless otherwise provided, death, insolvency, or otherwise incapable of entering into a contract is a disability, or whenever the firm is not registered or the person bringing the suit is not mentioned as a partner, a suit cannot be brought by the firm again for itself or against a third party. This is what section order 31 30 speaks about. So this is what all we have done today, and we just switch on to the interaction period, please.
Sir, కొంచెం పెంచండి.
Let's enter that.
Another 15 minutes. You got 1 hour. Start 1 hour. 15 minutes పెంచండి.
All right. Sir, CPC. 1 minute, please.
మీరు కేసులో చెప్పండి.
కేసులో లాస్ట్ చెప్తాను సార్ ఇప్పుడు కాదు. కేసులో ఏం లేదు. So, Order 31 speaks about suits by or against trustees, executors, and administrators. We'll go one word after another, please. What do you mean by trustees? Trustees means people who have been entrusted with the job of managing an institution and mentioned in the trust. They are the people who come into possession of certain property which is placed in trust, and they have to look after that property, manage that property, administer that particular property. They are called trustees. Or to put it in the legal parlance, an obligation attached to the enjoyment of the property is what it is called a trust, and the persons who manage are called trustees. Trustees, that is the then executors. What do you mean by executors? Executors comes in a contingency where a will is executed. The elderly member of the family or the person in whom they have got confidence is given the liberty to implement the will after the demise of the executor or the testator or the testatrix. If she is a female, they are called executors. And what do you mean by administrators? Administrators means people where there is a lull, where there's oppression, where there's mismanagement, a school or a college or an institution is not properly administered, then the government appoints an administrator to look after the property, manage the property, and run its day-to-day affairs. They are called administrators. Then what is the contingency in case suits are filed by or against trustees, executors, and administrators? It says that first one says in all suits concerning property vested in trustee, executor, or an administrator, where the contention is between the party persons beneficially interested in such property and a third person, the trustee, executor, or administrator, shall represent the persons so interested and shall not ordinarily be necessary to make them parties to suit. But the court, if it thinks fit, order them and that any of them may be made parties. So, in case of trustees, administrators, or executors, they need not be made parties. But in case the court finds that they are proper and necessary parties to answer certain questions, then in that case, they can be pleaded. They can always bring a suit as the trustee or as the executor or as the administrator of that particular property. The next one is all trustees, executors, and administrators shall be made parties to a suit against one or more of them. Sometimes misappropriation takes place, mismanagement takes place. One of the trustees tries to misappropriate the assets, misappropriates the money. Then one of the trustee who is aggrieved wants to bring a suit. Then in that case, suit can be brought against that offending trustee. Then husband of a married executrix not to join unless the court directs the husband of a married trustee, administratrix, or executrix shall not be made such a party in a suit by or against her. Suppose a suit is filed by an administrator or by a trustee or administrator or let us say executor. The husband has no role to play. Why? Because husband cannot take upon himself is to say, sir, I am the driver at home, I am the driver outside also. So the question is, husband has no role to play in such a suit. Only the executrix or only the trustee or only the executrix or the administrators can be made parties. This is a very, very small provision, please. This doesn't arise in real practice, but it's an academic provision that has been provided. Then we go to Order 32. There is a term used in law called duly incapax. There are certain people who suffer from legal disability. Can you name them, please? Under Section 6 of the Contracts Act, it is said a minor, unsound person of unsound mind, person otherwise disqualified from entering into a contract, or an idiot cannot be, they are not competent to enter into a contract. They are all supposed to be innocent persons who do not know the consequences of the act that they are doing or they are about to do. So the special provision is mentioned. That is, since a minor is, that is Section 11. I take you to Section 11. It's a contract with a minor, person of unsound mind, person otherwise disqualified from doing anything, or an idiot is void ab initio. That is, a minor has no capacity to enter into a contract. A minor cannot independently bring an action by himself because he is legally disabled from bringing a suit. So any suit that has to be filed by the minor or an unsound mind or an idiot or other disqualified by any law for the time being enforced will have to be brought by proper persons. Now we'll go one by one. Who is a minor? Minor in England is called an infant. In India, the age of, can you tell, the age of minority is up to 18 years. That is, a person till he attains the age of 18 years, he is not capable of bringing a suit by himself. A contract cannot be made directly with a minor. A minor is contractually incapable of entering into a contract and is also not liable for any misrepresentation, fraud, so on and so forth. So, whenever a suit has to be brought by a minor or against a minor, he has to be represented by his natural guardian. Then the question arises, sir, who is the natural guardian? Natural guardian depends upon the personal law of parties. As far as Hindus are concerned, natural guardian for a male boy up to 5 years is the father, and even later also. But as far as a female is concerned, a girl child, till she attains the age of puberty, the mother is the natural guardian. Then, suppose let us say father and mother are both separated, then in that case, who is the natural guardian? The natural guardian does not change, but natural guardian is a person who has got the custody of the minor, or the welfare of the minor is with the person in custody. So, whenever a suit is filed by a minor or to be filed by a minor, then it has to be filed not in the individual capacity of the minor, but the minor to be represented by his natural guardian, so and so, whomsoever it may be, father or mother, their address will be given. And in all cases, sometimes what happens once a natural guardian files it, then the court does not object to it, but it has to be brought by the minor, represented by his natural guardian. Then we go to person of unsound mind. Person of unsound mind is, what do you mean by a person by unsound mind? Divana. There is a person who is a uh, pichod. Then in that particular case, since he does not know anything, then in that case he has to be represented by his natural guardian or by his next friend, that is whomsoever is the nearest relative. Then in the case of person of a idiot, idiot means in Telugu the literal meaning is eddodu. He is not able to discriminate between what is right and what is wrong. Then in that particular case, he has to be represented by his next friend. Let us visualize a situation. A person is an orphan, a minor or unsound mind or idiot. Then in that particular case, the court appoints what is called a next court guardian. Court guardian is an advocate is appointed to look after the interests of the minor, look after the interests of the person of unsound mind or an idiot, and he conducts a case and prosecutes a case or defends a case for and on behalf of the minor, unsound mind, or idiot persons are concerned. So, a minor, a person of unsound mind, or an idiot are not capable of filing a suit by themselves. They have to be represented by a proper person. This is what is the purport of Order 32, Rule 1. Then, where a suit is instituted by or on behalf of a minor without a next friend, the defendant may apply to have the plaint taken off the file with cost to be paid by the pleader or other person by whom it was presented. Suppose, let us say, either by ignorance, either by lack of legal knowledge, you or me files a suit on behalf of a minor without getting him represented by his guardian or next friend, then the counsel for the defendant can object and also say to reject the plaint because it's not properly filed. Then, in that particular case, he can insist on the cost of the litigation to be paid to him. This is what Order 32 Rule 2 speaks about. Then, uh, here it is said, where a suit has been issued for him by his next friend, the court may at any stage, either of his own motion or application, and for reasons recorded, order the next friend to give security for the payment of all costs incurred or likely to be incurred by the defendant. Here, please remember, this provision has been mentioned because suppose you know that under the contract the minor is not liable. Then in that case, let us say the defendant is likely to succeed in the suit. Then in that case, the next friend, because the minor has no guardian or near persons, the next friend represents him. The next friend can be asked to furnish security to say that whatever costs are to be incurred by the defendant, he will reimburse the defendant with the cost that is likely to be awarded. This is what Order 32 Order 32 Rule 2A speaks about. Here, as far as I told you also, suppose a minor has no guardian or minor has no next friend. In that case, under the provisions of Order 32, Rule 3, the court appoints a court guardian. Court guardian doesn't mean that you become the father or mother of the minor. No. You take care of the interests of the minor as far as the court proceedings are concerned, either by prosecuting the case or defending the case. For all practical purposes, it is your incumbent duty to safeguard the interests of the minor, and that is the reason court appoints an advocate commissioner to act as court guardian for the minor concerned. That is what Order 32, Rule 3 speaks about. We'll stop with this and interaction period.
We'll have an interaction session right now.
Yes.
You can throw your questions.
Yes, sir. You're welcome. Please speak out your name and be a bit loud and audible.
So, I'm Soumya, sir.
Yes. Yes, madam. Go ahead.
Sir, I filed a suit for declaration and possession, sir.
Yes.
In that case, plaintiff died and they impeded the legal head.
Yes.
After that, one of the defendant also died.
Yes.
But the legal heads of plaintiff does not aware who are the legal heads of that defendant.
Yes.
So what shall I do now?
The procedure is you got a provision in the Order 22 itself, Order 22 4A or 4B, which says you
Order
can
22.
Yes, Order
Yes.
22 Rule 4 or 4A or 4B, where you can file a petition before the court to
Yes.
direct the opposite side to furnish the names, relationship, and address of the LRs. The court can order the other side or direct the other side to furnish the names. Yes,
Much.
All right,
Oh,
Mr. Garu.
thank you, sir.
welcome.
Mr. Garu.
Mr. Garu, please unmute yourself.
Sir, good evening, sir.
Good
This is
evening.
Krishna from Isaac.
Yes.
Sir, can you elaborate duties and powers of commissioner, sir?
The duties and powers of the commissioner is the warrant speaks about certain things to be done by you. For example, you take the case of a commissioner being appointed for the purpose of recording the cross-examination or evidence, let us say, of a person who is sick mentally and physically. Then in that case, the scope of your recording the evidence would be only to the extent of the pleadings that are addressed by the parties. If any objection is raised when a question is put, you try to put down the question and also give your finding, or in case you are not able to decide, you ask the court to decide on that particular point. And please remember here, I would caution you that there are two types of documents, one called the suit documents and another is called the evidentiary document. But it is the privilege of the commissioner, cross-examiner, to confront documents which are evidentiary in value and not the foundation of the claim during cross-examination. Then you cannot tell the advocate, sir, you cannot put these questions or confront these documents because you have not filed it in the suit. Please remember, even though you don't file it in the suit, it is a privilege of a cross-examiner to confront documents during cross-examination. And when you have any doubt, you put down the question and ask the court to decide on that particular aspect. That is as far as the examination of witness is concerned. Then second one is when you are asked to make an inventory, let us say, note down the things which are found at the particular place, then you have to only note down and initial at the place where you look into that paper or look into that page, and then also put your seal and put your signature also so that it cannot be tampered. And inventory, you cannot seal the shop. You can only note down what is found. This is a precaution which you have to take as a commissioner when you have been appointed for the purpose of making an inventory. The third one is when you are appointed as a commissioner to take accounts, then in that case, you must inspect the account books and try to initial every page and note down what is found in that page and the numerics which are found there, and then initial in every page of the account book so that it cannot be tampered, and put the date or put the date when you have made the inventory. That is, then fourth one is when you partition, when you are appointed as an advocate to divide the properties, you shall not allot the properties. Your job is only to go to the place, then take measurements, localize the property, and fix the boundary stones, and leave it to the court to make the allotment. Then, in the case of mean profits, if you are appointed as a commissioner to take down mean profits, then you ask the parties to produce the documents and give evidence before you.
All right, Uday garu.
Sir, can I, sir, shall I put
You're
my
welcome.
query?
You're welcome, sir.
Uday garu, you will have the question.
Yeah, thank you. Sir, it is
Sir,
like this, sir.
Sir, Vinod garu, please.
Vinod,
please hold on.
just wait, sir. One other person is in the line. I'll answer you next.
Uday
Uday garu,
garu,
please.
Thank you.
Yes,
Sir,
Mr. Uday.
Yeah, this is Uday. Sir, if the court asks us to issue a notice to the respondent, shall we go to home and issue the notices to
Not
the
necessary. You
respondent?
can give it to the council on record. You are talking about serving of summons, is it?
Yes, yes.
If you can go to the spot like a officer of the court and always make a duplicate and give the original to the party, and in the copy you say that you have served it at what time, at what place, and then signature of the party that he has been served and he has been given the notice.
If suppose if they were not at home or they are not
Then
taking
report to the court that the party is not found at the time when you went there.
Okay, shall we paste that in the walls or those things?
You can do it. You can say you have affixed it on the conspicuous place at the place concerned.
So shall we say that this is we are the amicus curiae and part of court we came? We were telling to them.
You can show your warrant also to say that you have come on behalf of the court.
But we are the petitioner counsel. So
Even if you are a petitioner counsel, you can say you have come on behalf of the court. You are given
We
the
can say
authority to serve the summons.
okay.
Yes, Mr. Vinod
Miss
Kumar.
Neha. Miss Neha.
Sir, Vinod Kumar Devan, sir.
Yes, no, funny. Miss Neha, are you there? Or else Balaji?
Sir, good evening, sir. I'm Balaji. Sir, please explain section 11 of CP, sir.
Sir, I'll come to it when I come to section, sir, because it has to be detailed. I have to explain to you in
Okay,
detail.
Okay, thanks, sir. Thank
Yeah. Next, sir.
and
Vinod Kumar. Vinod Kumar.
Snehita. Snehita.
Shall I proceed?
Yes?
Sir, this is regarding that company, your company, sir.
Yeah.
Company is a group of companies. One of the companies is a pharma company. They got innovations of products and they're given to some X company for the manufacturing.
Yes.
My submission is that when they're given for the X company for the manufacturing,
Hmm.
and between because of the after Corona, they're not been good market. They're asked to stop that production.
Yes.
Subsequently, what happened? X company has been told that
Please loud little bit.
yeah, the X company will told that the expenditure is incurred like 50 lakh rupees. You have to pay. Then we say the company said that no,
Sir,
we
please
asked
mute
to
your
stop the
mic. Please
Yeah,
mute your mic so that everybody is audible.
the company asked them to the tax company to stop the production, and he said that no, you have to pay the 50 lakh rupees because you said no. Now my submission is that they not paid. Our company is not paid that 50 lakh rupees to them. So he sued that in the commercial court. He got that ex parte degree against us. Now the company chairman is saying to me, sir, advocate sir, shall we proceed with the case ex parte degree to be set aside? Otherwise, we can file insolvency. If the insolvency will file, the existing directors of this pharma company, they will become null and void, and they become into the blacklist.
Right.
And what is the effect of the same directors in the other company?
Right.
Whether it is going to affect that directors in the other company,
So
the
the proper procedure for you is to file a petition to set aside the ex parte decree to safeguard the interests of your client.
Okay.
And question of insolvency or bankruptcy, go as a last resort. Don't go for it immediately.
Because insolvency will go for that. My submission is that any effect to the same directors in other company,
it doesn't affect the directors, sir.
It won't affect.
No.
They can go for the insolvency?
Yeah, they can go for insolvency, but tomorrow you cannot float another company and enter into contractual obligations.
No. My criteria is that existing in this company, in insolvency company, the directors are all they qualify again into the other companies or existing company?
No, there's no disqualification incurred unless there's a personal order against them declaring them as insolvent. It will be only against the company. Company will be declared as bankrupt, not the directors.
Yeah, only in pharma company, the directors ABC are become the insolvency, and the ABC are the in other companies also. That ABC directors will become any effect on that disqualifying in that company also?
No, not at all, sir. Not at all.
Not at all.
Not
Thank
at
you.
all.
Thank you very
Welcome,
much for this one, sir. Thank you.
Mr. Bhavani Prasad
Yes, sir.
and Mr. Anand Rao next. Bhavani Prasad, you can go ahead with your question.
Hello, sir. Good evening.
Good evening.
I have filed a petition under Order 23 and Rule 3 for compromise of the suit.
Not order 2033, sir. It is under order 23.
Yes, sir.
Bhavani, you are not audible, little bit loud.
Order,
Is it audible, sir?
order, yes, sir. Carry on.
I have filed a petition under Order 23, Rule 3, sir,
Yes,
for compromise of the suit.
yes.
The court officer transferred that suit to the Lok Adalat.
Right.
Is there any provision that court can order directly?
Court can always do it, sir, at any time. There is a provision called Section 89 of the CPC, which says the court also can order for matters being given to the Lok Adalat, but provided it is signed by both the parties and both the counsel.
It all done, sir. It all done.
It can do so, sir. Court can do it. There is absolutely no bar. That is what is
Okay,
called
sir.
alternate dispute resolution. That is called ADR.
Okay, sir. Okay, sir. Thank you so much.
Sir, good evening, sir.
Good evening.
Sir,
Yes, go ahead.
a sole plaintiff died
Right,
in a suit for a declaration of title.
right.
The logs of the deceased plaintiff,
Yeah,
mother and sister, came on records by a separate application.
right.
In the application filed by the son, he stated he got a will from his father in respect of this scheduled property.
Oh,
Now, he has not filed that will.
right,
Now, brother and sister both are plaintiffs.
right.
In respect of this transposition of proper parties,
Right.
so can the son come with an application along with will to receive the documents and ask for transposition of the co-plaintiff?
He can ask so, provided the other LRs are not taking proper action in the matter. He can say, my interests are being jeopardized. I have got independent rights. I have got to ascertain I have to get it upheld by the court. So he can definitely get transposed.
Yes. The other defendant, one of the sister made a party to the defendant.
Right,
Like the son, other
Right.
sister.
right.
But one sister is contesting along with his brother.
Yes.
So, can I seek a production of that will? Order 11, Rule 14?
Yeah, you can first give a notice to the advocate to produce the will. If it doesn't do it, then go to order 12 and file a petition before the court to direct the other side to produce the will and file it in the court.
Notice is mandatory, sir.
Absolutely.
But in the Order 11, Rule 14 says, I can very well ask without giving a notice.
But the normal precaution is to give a notice and file a petition.
Sir.
Right.
Thank you, sir. Thank you.
Anybody else? Shall we conclude the class for today? Nihita or anybody else? Have any questions?
Yes, Vinod Tande is here. One small one.
Sir, please keep your mic.
Okay.
Yeah, definitely.
It's okay.
Everybody
It's
can
okay.
hear it.
Yeah, please. Shall I go ahead?
Yeah, you're audible.
Yeah, it's okay.
Yes.
Shall I
yes.
go ahead?
Yes, carry on.
Sir, whenever this partition suit has been filed in the before the honorable court when it is under trial, suppose plaintiff number one, any plaintiff has been died, what is the rate of limitation they can bring to the notice and they can file the death certificate in the honorable court?
As far as the plaintiff is concerned, it is Order 22, Rule 3. You have to file the petition before 90 days. If you don't do it within 90 days, then you got Order 22, Rule 9. You got a further period of 60 days to set aside the abatement. In case even after that 60 days is over, you don't file it, then you got Section 5 of the Limitation Act explaining each days of delay and then ask the delay to be condoned. First, your delay petition will be heard, then your abatement petition will be heard, and then your LR petition will be heard. Am I right?
Sir, one of the case I was the opponent, I mean the defendant in the partition suit, where there what happened, sir? The LR, they only filed the memo saying that these are the LRs, these are the LRs, and already wife is the D2 is she is in the already in the on the record as a plaintiff number 2. My submission is that, sorry, as a defendant number 2, I'm the plaintiff. My submission is that if they file the delay of death certificate more than 90 days, then what is the next?
Then you can file a memo into the court.
suit?
No, you can file a memo into the court. The deceased is already represented by one of the defendants. No need of filing an LR petition.
And sir, one is the last one. I filed the money recovery suit. In that, I am the plaintiff. The defendant has been died, and defendant number 2 is wife, and she's already on the record. Now, other day they filed the memo saying that the children's also so and so in the LRs, but they not filed the death certificate. So, what next step I have to take as a plaintiff?
Yeah, non-filing of the death certificate is not fatal. Only thing is, once they say that the children are there, you better, for precautionary, you implead them also as parties.
But shall I directly, basing on the memo, shall I implead?
You can do it.
Thank you very much, sir.
Welcome.
Thank you once again.
Welcome.
Nihita, you're asking some question in the group. Please go ahead.
So my name is Srinivas.
Bit loud, please.
My name is Srinivas, sir.
Yes, sir.
Hello.
Yeah, I'm hearing
I
you.
want to ask a question about.
I'm hearing you.
Can you hear, sir?
Yeah, I'm hearing you.
My name తెలుగులో చెప్తాను సార్.
చెప్పండి.
ఒక ప్రాపర్టీ గురించి మార్కెట్ లో తీసుకున్న
సార్ కొద్దిగా
Sir, one request, please be loud.
పెట్టారు.
Please be a bit loud so that the other people can understand. If it is possible, please explain it in English because it is all over India is going on. So that other people also understand your questions. Please be a
అడగండి.
bit loud.
అడగండి.
One of the with in the property, they will register.
I'm not able to hear you, sir. I'm not able to hear you. Speak a bit loud. మీరు తెలుగులోనే అడగండి, పర్వాలేదు. తెలుగులోనే అడగండి.
రిజిస్ట్రేషన్ చేసుకున్నారు సార్ ప్రాపర్టీ డబ్బులు ఇచ్చి ఒకరికి.
Yes.
డబ్బులు ఇచ్చారు. డబ్బులు ఇచ్చి తనకు రిజిస్ట్రేషన్ చేసుకున్నారు. తనకు రిజిస్ట్రేషన్ చేసుకున్నారు. వాళ్ళ డబ్బులు ఇవ్వట్లేదు పార్టీ. 2 years ఇంట్రెస్ట్ పెట్టారు, ఇవ్వట్లేదు. అయితే ఏంటంటే వాళ్ళు పార్టీకి అర్జెంట్ గా డబ్బులు కావాలి. వాళ్ళు డబ్బులు తిరిగి ఇవ్వట్లేదు, మనిషి కూడా రెస్పాండ్ అవ్వట్లేదు. సో ఇన్ కేసు ఏం చెయ్యాలి అంటే థర్డ్ పార్టీ తీసుకోకూడదు అని అడిగారు. లేదా కేసు వేసుకోవాలి, ఎలా చెయ్యాలి అని అడిగారు సార్.
ఇది సపోజ్ వాడు డబ్బులు ఇవ్వాలంటే మస్ట్ హ్యావ్ సమ్ సెక్యూరిటీ టు షో దట్ దే ఆర్ ఇండెటెడ్ అండ్ దెన్ ఇన్ కేస్ దే డోంట్ పే దెన్ ఎన్ఫోర్స్ దట్ పర్టికులర్ సెక్యూరిటీ ప్లీజ్.
అదే అంటే థర్డ్ పార్టీ వాళ్ళు అనేది థర్డ్ పార్టీ వీళ్ళు పెట్టిన తనఖా రిజిస్ట్రేషన్ వేరే వాళ్ళకి పెట్టి తీసుకుని
this I will discuss when we discuss Transfer of Property Act, Section 83 of the Transfer of Property Act, which speaks about contribution or subrogation. When a person pays the money on behalf of another person, can you recover it? What is the procedure to be followed? We'll discuss it when we come to Transfer of Property Act, please.
Okay.
Yes, next.
Mr. Ravi Setu. Hello.
Yes.
Sir, namaste, sir.
Namaste.
I was appointed as an advocate commissioner in one partition suit. So, a partition suit lede adi ex parte decree kuda ayindi adi. Concern ఎవరైతే డిపెండెంట్స్ ఉన్నారో they are not responded for to taking of many notices.
Right.
Even the advocate council.
Right.
Sir, a small request from my end.
Right.
Yes. There are other people who are coming from other states joining these classes. Please ask your question in English so that they understand your question also. They get a knowledge of your questions.
Yes. Sir, I was appointed. Can I speak?
Please.
Sir, I was appointed as an advocate commissioner in one partition suit.
Right.
It is an ex parte decree.
Right.
So the plaintiff got ex parte decree,
Right.
and I was appointed for the securing the settled property.
Right.
For partition
Right.
suit.
Right. Right.
So in that, even the advocate, like in the defendant counsel also not represented, and his whereabouts also don't know.
Right.
So what shall I do, sir, for doing the partition suit?
You say, sir, you have given notices to the plaintiff and the defendant or the defendant's advocate is not traceable. In spite of my best efforts, I'm proceeding with the ex parte commission and I'm filing my report after inspecting the property.
To whom I'm going to give a notice, sir?
You have to give a notice to the last known address, sir. That's all.
Okay. After completion of
then report
all these things.
Yes, sir.
When I'm finally submitting the report, so that time I'm going to inform the court.
Exactly.
Yes, sir.
Exactly, sir.
Thank you, sir. Thank you.
Yes, Soumya.
Soumya already adiginda.
Actually,
Soumya, go ahead.
yes. So, if I'm dependent compromise before local adalat, the matter is closed.
Soumya, your voice is cracking.
Petition suit.
What suit?
Soumya, your voice is cracking. Please repeat your question.
Is it audible?
Not audible. Please come to the network and speak on. Soumya, are you there? All right. Let's make it up for today. See you tomorrow again. Bye-bye.
Kalyan sir, thank you.
Thank you.